Well, my name is Philip Tyrone with 720 System Strategy, here with Kenn Neeley, Neely Law, that has been discharging private and student loans through bankruptcy for the past 18 months. Kenn, how you doing?
Doing great. Thanks, Phil.
So the purpose of these videos, as we chatted about, is to educate consumer bankruptcy attorneys nationwide that times have changed, right? We're recording this right now in late 2022. And on November 17th, guidance was issued from the Department of Education stating specifically that the purpose of the guidance is to increase the number of student loan discharges significantly. And there's still an air out there with all the consumer bankruptcy attorneys we help that this may or may not work. And I just know you, and I've been on this path with you for the last 18 months. You've been doing this highly successfully, frankly, with every one of your cases, dozens and dozens of them for the past 18 months. I mean, can you speak into that just a little bit so people know, your background?
Yeah, I was tired of telling people we can't do anything about your student loans. And as we started to really attack that myth, we found that it is a myth, right? And it's a myth that's even told by some bankruptcy attorneys. So I would say, stop telling your clients that you can't do anything about their student loans. There were great options even before this new guidance, and now the options are even better for clients to discharge federal student loans. Private student loans have always been good candidates to discharge, and so it's been a great learning experience, and also it's been helpful for me to get to this point where now I can do more for my clients than I was able to do when I believed that there were no options on student loans.
And all your success over the past 18 months was under Bruner, this previous law that everything was sort of judged against. Now with this new guidance, I mean, it's as we mentioned, it's just going to get better.
Absolutely. Yeah, we're really excited and encouraged that it will streamline the process for discharging. There still are requirements to meet even with this new guidance, but there are now objective standards to measure the undue hardship as opposed to just what's left open to interpretation.
And I just want to point out, we're giving this information for people to use on their own. These are going to be tricks that you've learned over the years. But also, if you don't want to do this in-house, you can go to studentloanrelief.us. You can fill out these forms for your debtors, right? You fill this out. You put in here your name under how you heard how you submitted the information, and you, as the attorney, will fee share with Neely Law. Can you speak into that too, just before we move on to how to write a complaint?
Yeah, absolutely. So we love working with attorneys across the country to help them get some additional relief on student loans for their clients. And we will comply with your rules in your state to make sure that we pay you in a way that's ethical, whether that's a lot of times you're just going to be local counsel for us. And in any state, that's allowed and justified to pay local counsel a fee to work with us in that state. If we don't need you to serve as local counsel, we'll find a way to pay that as a fair referral fee. And it's great because it allows you to help your clients, give some additional relief to your clients, give them options, set yourself apart from your competitors, and then have us do the work that is technical and required in order to actually get that student loan discharge entered under court order.
And you've said in the past, Kenn, is, obviously part of the guidance is these people need to file bankruptcy in order to qualify for this. So, certain people that don't qualify wouldn't file bankruptcy on their own because they only have $2,000 in credit card debt or $5,000 or whatever. Now they're going to file because of it. And you said in previous calls where, your average case value has gone up $400 or $500 just simply because you're starting to offer this as an option.
Yeah, people are hearing from every attorney they call, well, we can't help you because most of your debt is student loan debt. And when we talk to them, we say, we can help you. Now, can we promise that, we can discharge these student loans in your bankruptcy? Maybe not, but as we've learned and become confident in which types of cases can receive relief, which is, as you mentioned earlier, pretty much all of them, then we're able to lay out those risks and rewards for our clients. And many of our clients file bankruptcy now just to deal with student loans. That's the primary debt issue, which would have been unheard of even just 2 years ago. And again, now with this new guidance, I think that number will even increase as we learn exactly how that new guidance will be applied. We'll be able to confidently tell people you can file bankruptcy and you can expect a discharge of your student loans.
So what we're going to do is we're going to educate you as the consumer bankruptcy attorney on things that Kenn has found over the past 18 months that work. Right. I have many consumer bankruptcy attorneys that told me, hey, I've tried this and it didn't work. It got kicked out of summary judgment. So we're going to unpack. Each video is going to have its own little lesson. You can scroll down below and see a link of all these other videos we have as they populate. But we're going to start with this one: how to write a good complaint so that it stands up to summary judgment. Because that's something that I've heard with many, many of my attorneys, that it hasn't worked because they've been thrown out via summary judgment. Obviously, it could be the judge, could be the district, but Kenn, lay out for us what this looks like. How do you think of writing a summary judgment, considering the fact that out of all the dozens and dozens of cases you've done this with, 100% have worked?
Yeah. So as you mentioned, some other factors might come into play a little bit: the district you're in, the judge the case is assigned to, the circuit, the prevailing law in your circuit. But I would say here in Arizona, in the Ninth Circuit, where we've filed most of our cases, we certainly don't have the most favorable law on student loans for debtors, right? We have Brunner standard here. We have conservative judges here who are generally going to favor the creditor. And so we have found that by having a very robust complaint, which means that we have done our research with the client, we've gathered documents, we've gathered facts, we have both documentary evidence and prospective testimonial evidence that will really support the 3 prongs of the Brunner standard. By gathering all of that, by knowing all of that, vetting all of that information, and then putting as much of that into the complaint as we feel is necessary to support the prongs of the Brunner standard, and having a strong legal analysis on the undue hardship. And then also on sometimes there are other avenues to relief in student loan cases besides just the undue hardship avenue to relief. So by putting those alternative causes of action in there and showing that we know the law and we are confident that our facts will support relief under the law, just starts the case off on the right foot, and I think really shows opposing counsel that is ultimately assigned to the case that we know what we're doing, we're serious about it, and then there's other things you can do post complaint as you're working with opposing counsel just to show that you're serious about carrying this forward. But the complaint is that first impression, right? And you want, as in everything in life, you want to make a good first impression. You want to show that you know what you're doing, that you're competent, that you're serious, and that you have a good case. And that will really just set the tone for the rest of the case.
So Kenn, let's talk about these 3 prongs you're talking about, right? Based on the guidance, it's current ability to repay, future ability to repay, and good faith, right? Can we unpack these?
Yeah. So what the guidance from the Department of Education has done is it's taken the Brunner standard, which has those 3 prongs that you just mentioned, and it has now applied some objective standards to those. So previously, we would argue the 3 prongs, and we would put in all the facts that we could think of, that we could argue to show that we met the requirement under the 3 prongs. But a lot of subjectivity, a lot of room for interpretation, a lot of uncertainty, and a lot would depend on the judge. A lot would depend on maybe your client, is your client seem to be deserving of relief, right? There's sort of these intangible issues that would come up a lot. And that's where having a very strong complaint was important. Now, as we have some objective, I call them check boxes, because they essentially were created. A lot of them are just yes, no. Has your client done this? Has the borrower done this? Have they done this? Have they done this? And if you can check a lot of the boxes under present ability to pay, future ability to pay, and good faith, especially something that was very uncertain in the past was future ability to pay. Now there are some objective tests for that. Also, good faith was a little bit hard to prove in the past, and now there are some check boxes for that. It's going to make this easier to do on a to assess pre-complaint, to have a consultation with a client and go through those items and understand that, yes, they have a very good case. And I will tell you, that is there are more borrowers than you think that will qualify under the new guidance. Even prior to the new guidance, there are more borrowers than you think that can get discharged. So the complaint, though, let me circle right back now to the beginning, still have to do the research, still have to make sure you have the good facts and make sure you know the law, because not every single case will result in a stipulation to discharge with the Department of Education and the U.S. Attorney's Office, the Department of Justice. And you need to be prepared. You're going to get better results in the settlement process if you show that you're prepared to go to trial if you need to. Okay. For any attorneys out there who do some personal injury work or are even familiar with how personal injury work works, you know that if you have a reputation of knowing the law and being willing to go to trial, you get better settlements with the insurance companies. I believe the exact same thing is going to apply here. If you're good at what you do, and you show you're serious, and you're not willing to just take a settlement offer from the Department of Education that you don't think is as good as you could achieve at a trial, and you're willing to go to trial, you're going to get better settlements. You just simply are. I think it's just human nature that's how things are going to work. Because even though there is this guidance, you still have people on both sides that are ultimately making decisions. You still have the AUSA, the Assistant U.S. Attorney, who's representing the Department of Education. And then you have some group, some committee of people at the Department of Education that are reviewing the recommendation. And ultimately, it's going to boil down to their decision. And if you can show how serious you are about taking it to trial, you'll get a better settlement.
I mean, truly, bankruptcy's been this sort of like, if I choose the bankruptcy attorney, my debt's going to get discharged black and white. I mean, very small nuances of this attorney better than this attorney. I mean, we can debate that later. But now with student loans, the attorney matters. And you need to communicate this with your debtor and with your clients, because all attorneys are not created equal anymore when it comes to bankruptcy because of what you're talking about. With an attorney that does not write, a good complaint, is not beef out, these check boxes, their attestation form, and is not willing to litigate, they're going to get lesser responses. So I just think from a marketing perspective, we're not going to go down that let's not go down that road. But this is very important to differentiate yourself as a consumer bankruptcy attorney. Now the times have changed, especially with this new guidance. You agree with that, Ken? I mean, am I off on that?
Yeah, 100%. So it is easy for a potential client to be shopping and thinking that bankruptcy representation is a commodity, right? And largely, I would say that to some degree that's true when you're looking at a case where the person is below median income, has no non-exempt assets, hasn't made any questionable transfers. You can kind of go through this checklist and say, yeah, I think probably any decent bankruptcy attorney in my state would get a discharge and would not run into issues in this case. But when you start to look at things like student loans and you start to look at some other considerations in a case, that's where you can set yourself apart as an attorney if you understand those additional factors. And right now, with how hot it is out there, the topic of student loans in the news, and among your potential client base, this is in politics even, right? I mean, this is out there everywhere. If you know student loans and can speak confidently to them and can speak confidently to your client's options to get a discharge, totally sets you apart, 100%.
So, Ken, let's go back to the complaint. Okay. So how are you incorporating, and I'd like to get a little more meat on this bone, if possible, with the new attestation form that you have? How are you using that to build out your complaint? How are you working in the current ability? I mean, because it is a checkbox and it's as simple as no, they don't do it. Is it a simple one-liner? How are you beefing that out? How are you talking about the future ability to pay, good faith?
Yeah.
How are you? Let's put some meat on the bone of the complaint.
Sure. Yeah. So what the attestation form gives us now is it gives us some guidelines of how to focus our information gathering process and our interviews with our clients, where before we had to paint with a little bit broader brush. We had to just kind of get everything we could because we didn't know what would ultimately be the most relevant facts. And now we know what the Department of Education is going to be looking for, at least during that attestation stage, right? And as I mentioned, it might not be resolved in the attestation phase. Hopefully, a lot of them will. Hopefully, most of them will. But so you still want to gather as much information as you can. But now you can focus in that pre-complaint stage, in the evaluation stage with your client. You can focus in on what's on the attestation form. Let's find out how old is your loan? How have you made payments? Have you sought help from a third party? How old are you? Some of these questions that are really important on the attestation form, we can make sure we go through those in our you can do it in your very first interview with your client, your initial consultation. Gather some of that information. Tell me about this, tell me about that, tell me about that. And you have a little form up on your screen or on your desk where you're checking off boxes. And now you have a great case because look, I cover present ability to pay, I cover future ability to pay, I cover good faith. This is a great case.
How many of your cases that you've filed have been that they've tried to dismiss via summary judgment?
Oh, I'd say probably half a dozen.
Okay. So of those, none of them were dismissed, obviously,
No.
right?
No.
Okay. Okay. That's great. Okay. So you just go through, you build out the complaint with following the attestation form. And then let's go to the need to be willing to litigate. You mentioned that earlier, but I just want to bring this up again. I mean, in those past experiences, what was that for you? Like, they need to know that they're not going to put something out and you're just going to accept the first one, right?
Yeah, I do believe it will really help in this process to be willing to turn down an offer to stipulate, an offer to judgment by the Department of Education, right? What I don't want to see attorneys taking an offer to have a partial discharge of only 10% of the student loans when they have a really good case, when they have really good facts, right? We're so early in this process, we don't know for sure that that's going to happen, but I can envision offers of, yeah, your client does have things kind of rough. Let's give a 10% partial discharge, because the guidance does allow the Department of Education to offer partial discharges as part of the stipulation. And if you have a really good case, you need a full discharge, right? And you need to be willing to tell the assistant U.S. attorney on the other side, thanks, but no thanks. Let's go ahead and get this queued up. Let's get into discovery and let's get a scheduling order done and move this thing towards a trial. And maybe that just would result in the AUSA going back to the Department of Education and saying, yeah, we got to do better than 10%. Or maybe you have to take it to trial, but don't be afraid to do that. That's what being an attorney and an advocate for a debtor and a student loan borrower is all about. It's rewarding to go take these cases further and be able to show the other side that you're serious about really helping your client and doing whatever it takes to get a full discharge or more discharged. Because again, even the courts could give a partial discharge, right? But you want to show the Department of Education and the Department of Justice that you're serious. You're not just going to take any offer.
Now, with all your cases you've done, the dozens and dozens of cases you've done, you've never had to go to trial yet.
No, no.
But you've pushed back and you've like walked the line, right?
Yeah, what we've learned is a little insider secret for anyone watching this video is we don't believe that the attorneys for the Department of Education, so this would be the assistant U.S. attorneys, the Department of Justice, or the attorneys that represent the private student loan lenders, they also don't want to go to trial either, right? So it's this back and forth of, hey, we're really serious about this, we're going to go to trial if we have to, and they're saying the same thing, and ultimately as trial gets closer and closer, settlement is reached, right? And it's a matter of we believe also they don't want to go to trial, they don't want bad case law, they don't want to spend the money on a trial, they don't want the work of a trial, the time commitment of a trial, all these downsides to a trial that kind of apply to both sides. It's a factor for the opposing side too. So take advantage of that, right? And be willing to push it all the way and go all the way to trial if you have to. But we have found that every case has settled so far. Some have settled very close to trial, but every case has settled.
Thank you, Ken. Okay, so we reviewed building a good complaint, how to build it, using the attestation form, and needing to take it to the mat. Like if you're going to all the way to litigation, whether that's going to happen, most likely not, or we just heard, but you just want to create that expectation for the people you're, in your negotiations. In future videos, we're going to talk about we're going to go through the attestation form, how to think about it. We're going to talk about pricing. We're going to talk about reopening cases. We're going to talk about private loans versus federal loans. We're going to have all these little videos released little by little with regard to Neely Law and 720 system strategies. If you have any interest in talking to Ken about your cases, you can go to studentloanrelief.us. The link will be below. And if you want to talk about bankruptcy attorney marketing, you can go to 720 system strategies. Ken, thanks for joining, and we'll talk soon.